The envelope was sitting on my kitchen counter when I got home from work that Thursday. I almost didn't open it. The return address said Clarkson County Probate Court, and I figured it was just a routine notice about my grandmother's estate being closed. I set my keys down, poured myself a glass of water, and stood at the counter, slitting the envelope open with my thumbnail. The letter inside was 2 paragraphs. I read the first one twice before the words stopped moving around on the page. It said the property at 412 Dunmore Lane had been transferred to a new owner of record following the completion of probate proceedings. It listed the new owner's name. It was my brother's name. I put the glass down before I dropped it. My grandmother had lived in that house for 41 years. She raised 4 children there, buried a husband there, kept a garden in the backyard that she tended every single morning until she was 82 years old, and her knees wouldn't let her kneel in the dirt anymore. When she died 14 months ago, her will was clear. I had read it myself, standing in her attorney's office 3 days after the funeral with my eyes still swollen. The house at 412 Dunmore Lane was to go to me, not split between siblings, not held in trust. To me, because I was the one who had driven over every Sunday for 6 years. Because I was the one who had taken her to chemotherapy appointments and sat with her in waiting rooms reading old magazines and holding her hand when the nausea hit. Because she had told me, more than once, that she wanted me to have it. My brother knew all of this. He had been standing in the same attorney's office. He had heard the same words. I sat down at my kitchen table and read the letter a 3rd time. Then I picked up my phone and called him. He answered on the 2nd ring, which surprised me. I had expected voicemail. "I just got a letter from the probate court," I said. There was a pause that lasted exactly long enough to tell me everything. "Yeah," he said. "I've been meaning to talk to you about that. It says the house is in your name. It's complicated. There were some administrative issues with the estate, and the house was left to me. I know that's what you believe, but there were some problems with the paperwork, and legally speaking," I hung up. "I want to be clear about something. My brother is a licensed attorney, has been for 11 years. He works in estate planning, which means he knows exactly how probate works, knows exactly what documents are required, knows exactly what the system looks like from the inside. When I hung up the phone that night, I didn't cry. I didn't throw anything. I sat at my kitchen table for about 4 minutes, and then I opened my laptop. My grandmother had used her own attorney for the will. A small firm downtown, a woman named Patricia who had handled her affairs for decades. I pulled up her contact information and wrote down the office address. Then I went to the Clarkson County Probate Court website and searched the case number from the letter. The case file was public record. That's something most people don't know. Probate proceedings, in most states, are public. Anyone can look at them. You don't need to be a party to the case. You don't need an attorney. You just need to know where to look. I pulled up the digital file index and started reading. There were things in there that should not have been there. The first thing I noticed was a document called a waiver of notice. In probate, when an estate goes through the courts, interested parties, meaning heirs, have the right to receive formal notice of proceedings. You can waive that right by signing a document. My grandmother's estate had a waiver of notice in the file. It had my name on it. It had what was supposed to be my signature on it. I had never signed that document. I had never seen it. No one had ever presented it to me. I stared at the screen for a long time. Then I printed everything. I called Patricia's office when they opened the next morning. Her assistant put me through immediately when I said my grandmother's name. "I need to come in today," I said. "Something is wrong with the probate file." Patricia saw me at 11 o'clock. I brought the printed pages. I brought the letter. I brought a copy of the original will that I had kept in a folder in my filing cabinet since the day it was read to us. She put on her reading glasses and went through everything without saying a word. I watched her expression change the way weather changes slowly at first, then all at once. "Did you sign this?" she asked, holding up the waiver of notice. "No." She set the page down flat on her desk and pressed 2 fingers against her lips. "Did you receive any notice from the court during the proceedings? Any letters? Any filings?" "Nothing. I got 1 letter, the one I showed you, 2 days ago. That's because the waiver was filed early in the process," she said slowly, "before the petition was even fully established. Once that document was filed under your name, the court had no obligation to contact you directly. You'd already, in the eyes of the court, been notified and agreed to proceed without formal notice. But I didn't agree to anything." "I know you didn't." She took off her glasses. "Who filed the petition?" I told her my brother's name. She was quiet for a moment. "He's an attorney. Estate planning." She looked at the pages again. Then she stood up, walked to her filing cabinet, and pulled out a thick folder. She went through it for a few minutes. setting pages aside until she found what she was looking for. She put it on the desk in front of me. It was my grandmother's original executed will. Patricia's firm held a copy. The language was exactly what I remembered. The house at 412 Dunmore Lane, clearly and specifically bequeathed to me. "Here's what I need you to do," Patricia said. "Today, not tomorrow, today you need to go to the probate court in person and file an objection. It's called a petition to reopen probate. You're going to contest the transfer on the grounds that you did not sign that waiver, that you were not properly notified, and that the transfer contradicts the explicit terms of the decedent's will. Can I do that myself? You can file the petition yourself, but given what I'm looking at, I would strongly recommend you have representation. What you're describing, if the signature on that waiver is not yours, is forgery of a legal document filed with a court. That's not a civil matter. That's a crime." I drove to the probate court that afternoon. The clerk's window at Clarkson County Probate Court was staffed by a woman who had the kind of efficient calm that comes from doing the same detailed work for a very long time. I told her I needed to contest a probate transfer and that I believed a document in the file had been forged. She asked for the case number. I gave it to her. She pulled it up on her screen and scrolled through the index. I watched her face the way I had watched Patricia's face. The same thing happened. Her scrolling slowed. She leaned slightly closer to her monitor. "Can I ask your name?" she said. I told her. She turned the monitor slightly so I could see it and pointed to the waiver of notice. "Is that your signature?" I looked at it for the first time on a large screen. My name, printed clearly. And below it, a signature that was supposed to be mine. I have a very distinctive signature. Everyone who knows me has commented on it at some point. It's large, left-leaning, with a specific way I loop the letters. I've signed my name the same way since I was about 15 years old. The signature on that document was nothing like mine. "No," I said. "That is not my signature." She straightened up and looked at me. "I'm going to ask you to wait here for a moment." She came back with a supervisor, a man in his 50s with reading glasses pushed up on his forehead. He introduced himself, shook my hand, and asked me to walk him through everything from the beginning. I did. He listened without interrupting. When I finished, he asked to see the letter I had received, the copies of the will, and my identification. I gave him everything. He went through the file. He was methodical about it, cross-referencing dates, checking the chain of filings, comparing the notarization on the waiver of notice against other notarized documents in the file. He stopped on something, looked at it for a long moment, looked at me. "The notary stamp on this waiver," he said. "Do you recognize this notary?" He turned the document toward me and pointed to the stamp at the bottom. It was a notary public stamp registered to a name I didn't know, but the license number was printed clearly. "Is this someone your brother works with?" the supervisor asked. I didn't know, but I wrote the name down. "I'm going to be honest with you," the supervisor said. "I can't make legal determinations from this window. What I can tell you is that there are inconsistencies in this file that warrant serious attention. I am going to flag this case internally. In the meantime, I strongly encourage you to file your petition to reopen today, and I also encourage you to contact the county district attorney's office, because if that signature is forged, this goes beyond a probate dispute." He walked me through the petition form himself. Took about 40 minutes. When I signed my name at the bottom, I watched him compare it, without comment, to the signature on the waiver of notice. He stapled everything together and time-stamped it. "This is now officially filed," he said. "The transfer is not automatically frozen by this filing, but it creates a record. Your attorney can request an emergency injunction to prevent any further action on the property while the matter is under review." I called Patricia from the parking lot before I even started my car. She had the injunction filed by end of business that day. That night, my brother called me 4 times. I didn't answer. The 5th time, I sent a text that said, "Talk to your attorney." Then I blocked his number. What happened in the following 6 weeks was not fast or simple. Anyone who has dealt with the legal system knows that it moves at its own pace, and there is very little you can do to hurry it. But it moves. That's the thing people don't always believe until they've been through it. The system is slow, but when you put the right documents in front of the right people, it moves. Patricia filed a formal motion to contest the probate transfer based on fraudulent inducement and improper notice. She submitted the original executed will as Exhibit A. She submitted a handwriting analysis comparison of my signature on file with the county from my voter registration, from a previous notarized document I had in my records, against the signature on the waiver of notice. The analysis was conducted by a certified forensic document examiner. The examiner's conclusion was clear. The signatures were not made by the same person. The probate court judge issued an order to show cause requiring my brother to appear and explain the discrepancy. I also filed a report with the county district attorney's office. I brought my documentation, my printed file copies, the handwriting analysis, and a written timeline of events. The detective assigned to the case called me back within a week, which I understand is fast. She told me the notary, whose stamp appeared on the forged document, had already been contacted. The notary said she had no record of notarizing that document. Her log showed no entry for that date. She had not notarized my signature because she had never met me. Let me explain something about how this kind of fraud works, because several people have asked me how it was even possible. In probate, there are windows of vulnerability. When an estate is filed, there is typically a period before formal notifications go out. If someone with legal knowledge, someone who knows exactly what documents need to be filed, exactly what signatures are required, exactly how the court processes incoming paperwork acts quickly in that window, they can file documents that reshape the proceedings before any other party is formally notified. The waiver of notice was the critical document. By filing it early, under my forged signature, my brother effectively removed me from the notification process entirely. I wasn't sent court dates. I wasn't sent filing notices. As far as the court's automated systems were concerned, I had already consented to proceed without notification. He had used his professional knowledge of the system as a tool to work around me, counting on the fact that I wouldn't know wouldn't know what to look for, and wouldn't receive any official mail that would tip me off until it was done. What he didn't account for was the letter. The standard closing notice from the court, sent automatically when a probate case is marked complete, the one I almost didn't open. The show cause hearing was in the 6th week. I was there. My brother was there with his own attorney. He did not look at me when he came in. He sat at the opposite end of the room with his hands folded on the table. His attorney argued that there had been a misunderstanding, that my brother had believed he had my verbal consent to proceed, that the signature issue was a clerical matter and not an indication of intent to defraud. Patricia argued that a verbal conversation does not constitute a legal waiver, that the notary stamp was fraudulently applied per the notary's own sworn statement, and that my brother, as a licensed estate attorney, could not claim ignorance of the legal requirements around consent. The judge did not rule from the bench that day, but she ordered the property transfer voided pending further proceedings. The house at 412 Dunmore Lane was returned to the status of an open estate, with a hold on any transfer, sale, mortgage, or encumbrance, until the matter was resolved. My brother's bar association was notified by the court. That is a separate process entirely, and I won't pretend I understood every step of it. What I know is that an attorney who knowingly files a fraudulent document with a court faces potential disciplinary action, up to and including suspension or disbarment. I know that an investigation was opened. I know that it was not closed quickly. The district attorney's office reviewed everything. Charges were ultimately filed for forgery of a legal instrument and fraud upon the court. I was not in the room when that happened. My detective called to let me know. My brother entered a plea. I won't say more about that because parts of it are still subject to conditions that I've been asked to respect. What I will say is that the property at 412 Dunmore Lane was formally transferred to me. I have a recorded deed in my name. I have a copy of the court order in a fireproof box in my closet, right next to the original copy of my grandmother's will. I drove out there on a Saturday morning in October. The house sits on a quiet street with old oak trees on both sides. The garden in the back was overgrown, 14 months of no one tending it. I stood in the yard for a long time looking at where her roses had been. Some of them were still there, scraggly and reaching sideways, but alive. I want to say something about my grandmother, because I think she deserves more than to be a footnote in a legal dispute. She was a woman who paid attention. She noticed which people showed up and which people didn't, and she never confused the two. She wasn't sentimental about it. She just had very clear eyes about the people in her life, and eventually she made decisions that reflected what she saw. I don't know if she anticipated what would happen after she was gone. I think she might have. I think she knew exactly who would try to take what, and she did what she could, while she could, to make sure that it went where she intended. She gave me the house because she trusted me with it. The least I could do was fight for it. If you are in a situation where a family member has died and left you something in a will, here is what I wish someone had told me. First, request a copy of the probate file yourself. Directly from the court, do not rely on anyone else to keep you informed. Second, review every document in that file and make sure nothing carries your name or signature unless you actually signed it. Third, If you receive any notice from the court and something feels wrong, do not wait and do not assume it is a misunderstanding. Probate courts are public. Estate attorneys are officers of the court, and forged signatures on court documents are not a gray area. My grandmother's attorney put it plainly when I thanked her at the end of all this. She said, "You did the right things in the right order. You went to the records, you came to me, you went to the court, and you didn't let anyone talk you out of what you already knew was true." I think about that a lot, especially the last part. Because when my brother called me 4 times that night and I didn't answer, a small voice somewhere was asking me if I had it wrong, if there was some explanation I hadn't heard yet, if maybe, somehow, I had misread the document. That voice was quiet, but it was there. I had not misread anything. The roses are going to take some work. I went back out on a Sunday, 2 weeks after I got the keys, with gloves and pruning shears and no particular idea of what I was doing. I found a YouTube video about restoring overgrown rose bushes and followed it as best I could. Some of what I cut away was dead. Some of it wasn't. I'm going back next weekend. And the weekend after that? The garden is mine now. I intend to take care of it.